To the Point with Michael Williams.
Good morning. The latest indictment of former President Donald Trump, and today the Florida focus. He faces 3 indictments right now, 2 of them federal, and one of those involving the Mar-a-Lago classified documents case. How does that compare and contrast with the Washington, D.C. federal case and allegations there that he conspired to overturn the 2020 election? Dave Bowman sets our coverage.
Is this going to affect the Fort Pierce trial? Maybe not. This case could be set to go to trial in October of this year. Could be set in November of this year, December of this year.
Former federal prosecutor David Weinstein says the case against Donald Trump, accusing him of illegally trying to overturn the 2020 election, could go to court sooner than many expect. Weinstein says charges in D.C. have fewer pretrial issues to be hashed out than the Mar-a-Lago documents case. In Fort Pierce, classified documents need time-consuming reviews to determine how sensitive information can be handled in court. There's no classified material in the D.C. case. Weinstein says Trump's lawyers are likely to challenge the Mar-a-Lago search warrant. There are no search warrants in the elections case. Donald Trump faces 37 criminal counts in Fort Pierce, just 4 in D.C. And in the documents case, he has 2 co-defendants. In the elections case, he faces charges by himself.
As I stand here right now, it's a single defendant case, 4 counts, and a lot of overt acts. So it's something that the judge could push to go to trial inside of 6 to 8 months.
Of course, everything's subject to change, but as he says, where we stand right now. My guest this morning to begin with, Mark Schnapp, former Miami federal prosecutor, talking about both the Fort Pierce case, the classified documents case, and, of course, the latest indictment out of Washington. His perspective.
Of the Fort Pierce case, yes. The strengths are that it's a relatively straightforward case. That it's that these are sensitive documents. They're all of them classified. They deal with national security information. That he didn't have the right to retain them. He had multiple opportunities to return them. He did, and certainly the case, and then also that he misrepresented the facts to his own lawyer, Evan Corcoran, that the documents were produced, and then later he tried to have security footage deleted at the Mar-a-Lago estate. That's the strength from the government point of view.
Weaknesses of the case?
The weaknesses are his ultimate argument that he believed that he had the right to retain these documents. I don't think that goes very far. I think that's really his basic argument. That he thought that these were his documents, and he didn't. With respect to the obstruction count, that he didn't actually order anybody to delete anything, or in fact, it wasn't deleted.
It's not a purely legal question, but speak to the argument again and again from the president and his supporters that all of this, from Fort Pierce to Washington and beyond, is just a witch hunt. Speak to that. I know it's not a purely legal question.
Well, in a sense, I guess it is. He's going to argue ultimately it's selective prosecution. So,
is it?
I don't think so. I think there's a good basis in both jurisdictions to be prosecuted. And the irony, Michael, is that I think we alluded to this briefly before, is that the one person who tried to weaponize the Department of Justice, as alleged in the indictment, is Donald Trump.
How do you mean that?
Well, he's alleged to have met with Jeffrey Clark, who's a Department of Justice official, in order to, where Clark offered to open investigations into the voting process of the certification process of the election. And he was misusing his power as a Justice Department official.
We're not talking about the Washington case, of course. Talk about strengths from the prosecution point of view, weaknesses, the arguments that you think will be marshaled most firmly by both sides in Washington, where he's alleged to have tried to overturn the election.
I think the most difficult argument for the government is the fact that several of the lawyers who were advising him were in fact Trump's lawyers, with the exception is Jeffrey Clark.
How do you mean that he can argue that my lawyers told me I should challenge this? They agreed with me, some of his personal lawyers, whether it was Rudy Giuliani or others.
I'm sorry, that is the challenge for the government. Let me clarify that. I think from a government point of view, the most difficult issue is going to be the fact that Donald Trump had multiple lawyers advising him that he could take the actions that he did, including, John Eastman, who's a former dean of a law school, a known constitutional scholar, who authored a memo advising a certain strategy to try to convince Mike Pence that he could refuse to certify the election results. The one lawyer who's the outlier is a former Justice Department lawyer.
It would seem also, though, that the countervailing argument from the governments are going to produce witnesses, including Mike Pence. Want to talk a little more about him, who are going to, whether it was Mike Pence, whether it was his director of national intelligence, whether it was his Justice Department, Bill Barr, the former Republican attorney general, on and on and on, who told him no fraud here, no stolen election here. That's the prosecution case that's fundamentally going to be argued again and again through witnesses.
I mean, and also not only at the federal level, there was also in the indictment, there's alleged interference at the state level with certification of the results. And even the state officials told them, look, we didn't have any election fraud or in our jurisdictions, including the allegations about dead people voting, those kind of things. So, I mean, he's told at multiple levels, both in the federal and the state level, that there was no fraud.
Which case is likely to go first? The one here that will happen in Fort Pierce, scheduled for next May, or the Washington, D.C. case, if you were making a legal bet?
You know what? It's interesting you say that. My gut is that the D.C. case will go first, and for a couple of reasons. Number one, you don't have the Classified Information Procedure Act issues. You have yet a third defendant who's been added to the case in Florida. DC, you have one defendant. You have a different kind of judge. You have a judge who's more aggressive about moving her calendar. And so I think that the two judges, the federal judges, will coordinate themselves. Coordinate between themselves as to who goes first. But my gut is that the DC case goes first.
You know John Lauro, his lawyer in Washington. You have personal, professional acquaintance with him. Tell us about him. And I'm talking about Mr. Trump's lawyer, his lawyer in Washington.
Yeah, I've known John for a very long time. He's a terrific lawyer. He is smart. He's a former federal prosecutor from the Eastern District of New York. He's a Florida lawyer, actually. His office both is in Tampa and New York. In my personal opinion, he is as good as they come. He's a very experienced trial lawyer. And so I think one of the things that, in my opinion, that President Trump did was he picked a very good lawyer to represent him.
Talk about already, Mr. Lauro's been saying we need to have a change of venue here. You can't get a fair trial in D.C. How easy is that to get a change of venue?
Almost impossible. I can tell you that several things. Number one, it's very rare. I mean, think about the Boston bomber case, which was actually, there was a motion for change of venue and it was denied. Why? Because the court found that there was enough people who could give that person a fair trial. The only case that sort of sticks out in my mind where a trial was moved was the Oklahoma City bombing case, where it was in fact moved to Colorado, but that was an outlier. Michael, to make a motion for a change of venue, you have to show that you can't get a fair trial. And that's a pretty tough thing to do.
Do we see former President Trump take the stand in either case, Fort Pierce or Washington, D.C.?
No way. I think that would be the worst possible thing he can do. First of all, he has no ability. His ability to control himself is about zero. He'll get on a stand and talking about the weaponization of the Department of Justice and how he's being treated unfairly. And I just think it would be a big mistake. The only thing he can say in the Washington case is that I believe I won, and I had a First Amendment right to do what I did.
Very briefly, quick thumbnail, star witnesses or key witnesses, first in the documents case to be tried in Fort Pierce, then the Washington case, then one final question.
Okay, and in the documents case, I think you get You have the people who did the search, his former lawyer, Evan Corcoran, who made a statement to the department, that documents have been produced. You have the person who's been identified as witness number 4, who was allegedly called to delete security footage by Nauta, who's a co-defendant, and ultimately by Trump. And so those are going to be the key witnesses. From the defense, hard to say. I mean, I don't know what the defense ultimately is. I'm sorry.
And in D.C., is Mike Pence far and away the key star witness?
I think Mike Pence is clearly the star witness. He had nothing to gain. Only, what he would have had to gain is if Trump was right, is the ability to be the, vice president again. But I think it's not only Pence. You're going to see high-level officials from the Department of Justice, the former Attorney General, Bill Barr. People at that level, who will more likely than not be defended, be called. But although interestingly enough, this morning I did see an interview with Bill Barr where he was asked whether Trump actually believed that he had lost, and he said, "I think so." I mean,
but for all of the talk and concern and complaints from Republicans and former President Trump that Democrats are after him, when it goes to trial, it will be Republicans like Bill Barr, like Mike Pence, like others who were in his administration, who will be making the arguments that the prosecution will use as the key of their case. Republicans, not Democrats, obviously.
Well, they'll be the fact witnesses, yes.
Yeah.
I'm sorry.
No, it's just, do you find that an intriguing, given all the talk about weaponization, is that intriguing to you?
It just shows that the weaponization argument is complete nonsense. I mean, I think, as I said before, the only person who's alleged to have misused the Department of Justice is Donald Trump in the D.C. indictment.
Mark Schnapp, a former federal prosecutor in Miami. Final thought: can this country's legal system, political system, hold under the strain that it's about to be put under? What are your concerns and thoughts? Final thoughts.
No, I think it can. I think that you'll never see a case like this ever again, hopefully. But I think that this is a true test of the fact that, people will be held accountable, and that people ultimately who are being held accountable, no matter what level, can get a fair trial.
The Roundtable and Brian Crowley next.